So what you're going to do is you're going to put that child on the flight. Good morning, we're ready for the matter. If I could get cameras on for everybody, please. Thank you. I see that is on Zoom, as is Farran, your appearance.
Good morning, Your Honor. Erick Farran, 9554 for present with me, as well as my paralegal, Karen Press.
Okay, Ms. Marr.
Good morning, Your Honor. Patricia Marr, 8846, and I'm appearing on behalf of Mr. is present, also via Zoom.
Okay, thank you. I have read all the pleadings. This is a case that was reopened after some litigation last summer. I am well versed with the history, so I will save everybody the time of having to go through all that. But I did read Dad's motion filed January 12th for the immediate return of the minor child. According to Dad, Mom has still not completed or enrolled in the counseling. He is asking for a psych eval at her expense. He is alleging that there is an invoice remaining of $88.26 that remains outstanding. He describes to me what happened for the Thanksgiving break and now the winter break. According to his information, he provided an itinerary for Thanksgiving on October 6th. He provided an itinerary for winter break travel October 7th. For Thanksgiving, she was due back on November 30. However, Ms. told him that she did not put the child on the plane, and the child ended up back in Texas on December 1. That allegedly Ms. to pick up the child at 6:30 at the airport, but Dad discovered that Mom had actually arrived earlier, had driven the child around town, did not take her to school, and while she was relatively close to Dad's address, ended up going back to the airport, dropping the child back there, and causing not only a delay, the child missing school, but the inconvenience of having to pick her up at an airport where the child had already been closer to Dad. Then on December 2nd, Dad tells Ms. That he is counseling the return portion of the flight for the January 4th travel due to her history of not taking advantage of the flights, canceling them, and then, or not using them and then purchases her own anyway. He said he was willing to reimburse the child's portion of the flight with conditions, meaning, we all know what those conditions were. Don't, book last minute, don't increase the cost, things like that. He indicated in his pleadings that while he told Mom on December 2nd he was going to cancel the flight, he actually didn't do that until 30 minutes prior to the flight, once he had confirmed that the child had not boarded the flight, and that was written in a footnote. Bottom line is that the child, according to the pleadings in January, and I'll ask for an update, remains in Nevada. He also alleges that despite my court order indicating that she needed to file the amended returns or pay him $500, which was a consequence, not an option, she exercised the option of paying him instead $1,000 and still hasn't amended her complaints. Then he makes a request to clarify the health arrears time period, and he's asking me to issue an order show cause for her not completing individual counseling, for returning the child late summer, for returning the child late in Thanksgiving, winter break, for not amending the tax returns and not complying with the 30/30 rule. He filed exhibits, which I reviewed. I granted an order shortening time. And then Mom filed her opposition and counter motion, basically indicating that she is relocating to Texas soon, so the request for future travel protocol is not necessary. That she is willing for the child to return to Texas, but that Dad has to pay. That she has completed counseling and has reimbursed the outstanding bill. She further argues that it's Dad's fault for creating this issue because he canceled the flight. And then I read all the exhibits. So everything that I gathered, I want to start by pointing out that the issue of the child flying unaccompanied came before me. And I believe Ms. is misinterpreting this court order. I did not say that the child could not fly unaccompanied. What I said was that I was not going to make that decision and that it was the parent's decision whether she fly unaccompanied or not. So if Mr. the child to fly unaccompanied, the child can fly unaccompanied. It's his choice, not mine. So Ms. now turned my words into saying that I denied his request. What I denied to do is to make that decision. I said that it was a parental decision. I've never met. She's 6 years old. It's not my place to say what I would do with my own children. But if Mr. feels that this child can fly unaccompanied, then he could do it. But Ms. has turned this order around and used that to say the court denied your request to fly unaccompanied. That's not what I did. So I wanted to start off with that, but Ms. Marr, we'll start with you if you have any updates.
I do have some updates, Your Honor. The child remains in Las Vegas. My client obviously wants her returned ASAP. He's had to disenroll her in school so that she did not have to repeat first grade, because once there's so many absences, that's what would happen to this child. With that being said, he can re-enroll her, but he did that so that the child wouldn't incur further harm to the child. With that being said, Dad has spoken to the teachers in Texas. Since Mom has kept the child past the past the point of return, Mom hasn't even reached out to the school in Texas to see if she could facilitate maybe keeping this child on track. It should also be noted, Your Honor, because I questioned it, but the name is attached to that unaccompanied ticket. So she had full knowledge, she had access to it up until, she didn't put the child on the flight. And I think it's also notable that my client said, look, you did this at summer, you did this for Thanksgiving, and now so that we don't have to go through this in December, you get the ticket because you're gonna, it looks like you're going to want to fly with her anyway, and I'll reimburse you for it. He's trying to make things less complicated. And with that being said, she agreed. She said yes. And so then when he follows up and says, and this is beginning of December, give me the itinerary, let me know. She just ghosts him. And there was a period of 5 days prior to the day that the child was supposed to be returned in January that she didn't even respond to him. But this has been a pattern for her. And that's why it's so troubling, and she needs that evaluation that she agreed to, and then there's a refusal, and I surmise that I know why, because it's not going to be returned favorable for her. With that being said, I think the court gets the picture. I mean, she shows up in Texas. This little girl should be in school, and she's driving her around Texas. This is where mommy's going to live. I'm coming here, but don't you dare tell your father. I mean, this child's 6 years old. Do we really have to? I mean, it's twisted. It's just a healthy parent doesn't do that. And whether she's moving to Texas or Baltimore, it doesn't matter. We're living in the present. And so she just wants the court, from what I gathered from her pleading, like, oh, don't worry, I'm going down there anyway. We don't have anything solidified, and that's not the issue before the court anyway. But right now, I think we're at 42. When I filed my reply, we're at 42 days and counting compensatory time. And it's just, as I said in the pleading, it's just more of the same. That's why we're here. But this child needs to be returned. Oh, and the icing on the cake, Your Honor, and then if you have any questions, I'm happy to answer them, is this is against the backdrop of my client thousands of dollars in child support. Thousands of dollars. And here we are.
Mr. Farran?
Judge, I'm not going to regurgitate my brief. I mean, procedurally, just as a matter of course, the OSC motion is deficient for several reasons. And we briefed that judge just right off the bat. Second, just finished a high conflict trial for Judge Warden. And, right, this is one of those cases where, they're just never going to see eye to eye. And each side kind of takes what he or she can get. He told her that the flight was canceled. I don't know what kind of game they want to play about saying, well, this or that, or that she was on the ticket and she knew, or she didn't put the kid on the plane, or he's playing some 30 minutes before this thing, the kid's not on the plane. If she receives a message and inquires, and he says the flight's canceled, I mean, what's she to do? On the unaccompanied minor thing, I agree with Your Honor. I looked at the provisions, and I certainly I don't know so much that she's misusing Your Honor's order as opposed to what you stated. It's a parent issue, a joint parent issue. They're joint legal custodians, and I don't think she feels comfortable with a 6-year-old flying alone. So it's something that, unfortunately, they're unable to discuss and figure out together, like many of the issues on this case. Judge, in terms of the schooling, she reached out to teachers. She reached out to. He didn't tell her that. He didn't tell her. He didn't tell her that she withdrew the kid from the school. She's trying to do everything. She does have limited funds. I'm not talking on this case for a ton of money. I'm doing this because I know she's relocating back or to Texas to be closer to the child. And obviously, at that point, both parents will be in Texas. And, I'm sure the case will continue there. In the interim, Judge, I'm happy, obviously, to somehow send the child back. But, it was his cancellation at the very basic. Even if it wasn't a real cancellation, it was his cancellation and not hers. And then he wanted her to pay for it.
Okay. Thank you. I'm sorry. I didn't know if you were done. There's a delay.
And again, you get this text or message on December 2nd, and then now you're trying to buy tickets, when they're $1,000 as opposed to, $250 when he offered.
Thank you. So,
sorry, she's done the counseling. These parties have both engaged in conduct, which, they should probably both undergo a psych eval together. I don't think that's really appropriate. And like I said, in about a month or so, this court is going to, the owner's going to be domesticated in Texas. So she's moving there February 28th. She's locked down employment there and housing. And so just to comment briefly on the idea that notion that she's driving this child around Texas, that's just misstatement. The exchange occurred at the airport. He knows that. And the other issue that's pertinent in this, he made a list of demands, right? If you want me to do this ticket, then you've got to do all this stuff, including not exchange at the airport, but drive the child and incur additional expenses, rent a car seat, drive him all the way from the airport to my house, and deliver the child as well. But then you're doing exchanges at the airport.
I go back to the order from August 7, 2025, where the court specifically addressed the issue of the child flying, and the court states, and I'm quoting my own order, no orders will be made regarding whether the child should fly unaccompanied or not. And in Dad's motion, he states that he provided the winter break itinerary October 7th. If Miss had an issue with the child flying unaccompanied, Miss purchased a ticket on that day to fly the child back to Nevada on January 4th, when the child was due. Okay? Instead of doing that, which a reasonable parent would have done, nope, they start playing this power play. Okay? I am not pleased at all with the way this did. But I also know Ms. Hall's shenanigans just from being on the case a few times, and I can see why he would have done that. Should he have done it? Absolutely not. I would have eaten the ticket price on that and let Ms. hang herself from the proverbial legal tree for not following the court order. But that's not what you did. Now you're engaging in similar behavior, and you have created a problem here as well. But Ms. plenty of opportunity to say, you know what, the judge said she was not making any order for the trip, so I don't want my 6-year-old to fly, so I'm going to fly with her on January 4th, and that will be the end of the story. But no, she decided to manipulate the court order and try to make it in her favor. At the end of the day, we have a child who has not been in school for 42 days, or however they have been at this point. I don't think it's been 42, but she's not where she needs to be at this point, and it's because the parents are playing this power play. I can't believe that the child has been unenrolled. What else was he supposed to do? You have made no effort to get this child back, and then you conveniently put in your pleadings, well, Dad could pay to get her back. You know what? He did. He did pay to get her back. And you played this game, and now you're both hurting the 6-year-old that should have been in Texas on January 4th. So with regard to the contempt, I agree, Mr. Farran. Procedurally, the motion is very deficient as far as a contempt proceeding, but the court can enforce the order because it's very clear that the order is not being followed. So this is going to be the court order, and the child has to be on a plane to Texas by tomorrow at this time. It's going to cost both parties money. And I know that she's allegedly moving to Texas, and she's comforted in knowing that this will proceed going on in Texas, which I don't even know why you would be excited about continuing litigation in Texas. But for now, it's a Nevada issue, and I'm going to deal with it. So with regard to the child, and I'm going to take the issue one by one. The child has to be on a flight by noon tomorrow. Dad is going to book the flight. He is going to pay up to the amount that he would have paid had the child gotten on that flight. I don't have that amount. So for example, and Ms. Marr, if you could dig that up right now, it would make life easier so that we have it all clear. If Dad paid $200 for a round trip flight for the child, he is going to pay up to that amount. And Ms. is going to pay the difference. Dad can book the flight just for the minor child because he wants the child to fly unaccompanied, and that's his decision. I'm presuming it's a direct flight. I'm presuming he's going to book it as an unaccompanied minor, which the airlines have protocol, which means he could be at the gate until the child boards, and he hands her off to a flight attendant. They seat them at a specific section of the plane. They keep an eye on them. The airlines are liable for this child, so they're not going to put her in row Z next to whomever. They take care of these kids. And I understand this. You probably don't want the child to fly unaccompanied, but you have a remedy. Fly with her yourself. So then, Miss is going to Venmo, Zelle, or whatever, Dad the difference for that flight today by 5 p.m. So Mr. flight needs to be booked by 1 p.m. and mom has to send you the difference by 5 p.m. And here's a heads up. I know mom has a history of non-compliance. So what you're gonna do is you're going to put that child on the flight, miss, whether you have paid dad or not. And then I will deal with you when we come back next week sometime. I'm gonna squeeze you in to make sure the child returned. And if you have not paid him back, like I told you to do by 5 p.m. today, Nevada time, then I will deal with you accordingly. But that child is on that flight before the time I announced already tomorrow. And I'm just saying that because I don't know flight schedules and all that, and I want the child on the next flight, but I understand, right? It may not be possible. Miss Marr, were you able to figure out how much dad paid on October 7 for that child's flight?
I am told that it is approximately $200.
Okay, well, he should have that, right? So what I want you to do, Miss, open up your micro, or I don't know what airline. Are you able, and you could put thumbs up if yes, thumbs down if no. Are you able to get that information quickly for me during this hearing? Thumbs up or down? Okay, so start looking for it, and when you find it, open your mic, because I am going to make this order crystal clear, because I don't want anybody to mince my words. I'm putting them on the record. They're being recorded. I'm sure you're all taking notes. We're gonna get those amounts to the penny, to the extent that we know what dad paid, and mom's gonna be responsible for the difference. And that child is coming home today. I'm going to set a hearing for next week. And Ms. Marr has to file a brief before next week, I'm sorry. It's a very short brief on how many days that child was not with dad. I know you stated the number, but at the end of the day, I need an update because I haven't received an update since you filed your motion.
Judge, I didn't mean to interrupt. When you were issuing your mandate right now, Judge, you said the child has to be home today.
No, I said on a flight by. Okay, what did I say?
Flight by tomorrow, but then you did say the child.
Okay, ideally the child should be home today, but I did say she needs to be on a flight by noon tomorrow. While I want it to be the next flight, right?
Yes.
I understand that may not happen, and therefore no later than 12 noon tomorrow.
Understood.
And I mean flight in the air.
Yes, Your Honor, I get it, I just wanted to.
I appreciate your request to correct that. Next issue, the counseling. Mr. Farran, I know that you presented whatever your client gave you, but an appointment reminder is not a completion certificate. And all you gave me in your pleadings were appointment reminders, that she had an appointment scheduled this day and she was being reminded. That doesn't mean she went. That doesn't mean she completed the schedule. So I'm not satisfied that she has completed counseling because I haven't received a discharge letter, a letter from the counselor. Her appointment reminders are not enough to satisfy that request. Regarding the tax returns, in her pleadings, she did not rebut the allegation that she paid him $1,000 instead of amending the tax returns. Miss N trying to manipulate things in her favor. I did not say amend or pay. I said amend. And for every month that you did not pay, you will be fined $500. So guess what? She needs to amend those returns. And this is what Ms. is going to do. Mr. is going to file his tax return for the year 21-22. He's no longer going to wait for her to do the amendment. According to his pleadings, he hasn't filed his returns at all. So generally how the IRS handles it is you file a 21-22 tax return claiming the child, and another person does the same thing. They're going to send an audit. And at the end of the day, he likely will prevail because there's a court order that he should have been the one claiming her. And whatever Ms. received for that tax year as a refund, the IRS is going to deal with it. I'm sure they have a way of handling that portion.
Can I inquire briefly? I'm sorry, Judge, just because I wasn't part of that litigation. She's stating to me that she did pay the $1,000. It was $1,000 and amend?
Yes, I never said don't amend. I said amend, and it's written in my order. Next thing.
I do want to make it clear that she did pay $1,000 as well. So, but it's crystal clear now, Judge. Thank you.
Okay, but she hasn't amended it, and that's the issue right here.
Yes, Your Honor.
Okay? According to her, she already paid the invoice. Is that correct, Ms. Marr? I didn't get an additional pleading, the 8826. Okay, I can't hear you.
I believe she did, she paid that.
Okay, so that issue has been resolved. So I'm not issuing an order show cause. The affidavit does not meet the requirements of NRS 22 and AWAD. I understand that OSCs are not very easy, but they are very serious. And they come with serious, and so the court as a gatekeeper needs to make sure that procedure is followed. But I am enforcing the order. I'm going to set a quick return date, and Ms. Marr is going to file a brief with all the compensatory time. I understand that she is denying that she drove the child around on December 1, but the point is the child should have been in Texas November 30. And there she goes again, getting an extra day because I can't speak for her, but I'm also not very clear as to why she continues to put herself in a situation where it's not helping her plea. And all these violations are part of the case history that will be registered in the state of Texas. So the reason I want you to bring back the case next week sometime, and I think I have time on the 12th at 11, so please start checking your calendar, is I want a full list of the compensatory time for summer, Thanksgiving, and winter break, so that it's part of the record and the Texas court knows her history and knows that Mr. entitled to compensatory time. I'm, again, not pleased with him and the way this all went down. This is so harmful to your child. And Mr. a little bit more proactive on getting the child back, even if it cost him a few extra bucks for the sake of him not being considered, just as with unclean hands as Mr. That you're back on the screen. We're going to have you raise your right hand regarding this pair. So raise your right hand, please.
You do solemnly affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, under pains and penalty of perjury?
Yes.
Okay, Mr. Find how much the fare was for the minor child's return when you booked it in October.
Yes, it was $282.
$282. And you have proof of that, correct?
Yes.
Okay, so your instructions are to pay for the child's flight back to Texas. You have a credit up to $282. And Ms. is going to reimburse you the difference between $282 and whatever you have to pay to get the child back to Texas. You're going to send your attorney a copy of that receipt, and she's going to send it to Mr. Farran right after you book the flight. She's going to send him the itinerary, she's going to send him the receipt, and by 5 p.m., that payment will be in your, hopefully, bank. But if it's not, the child gets on that flight and I will deal with why it wasn't paid February 12th at 11 when I see you back. I am asking you to pay. I want to make sure you understand what I just said. Do you understand? Or do you have any questions that I need to answer to clarify?
No, it's very clear, Your Honor, and just as a matter of record, I can book a flight that leaves Las Vegas at 3:30 this afternoon.
Okay, you have it already, like, you're for sure?
I just have to purchase it, but yes.
All right, so we're anticipating the child will be back in Texas today. Ms. Marr and Mr. Farran, you know, I understand we all have things to do, but if you're not available, you need to have somebody of your staff available to transmit all that info. Because I don't also want to hear my attorney left for court and I didn't see them again, and then the child got stuck here because the attorneys weren't available. Ms. Marr, do you understand what you're expected to do?
Yes, a couple things, Your Honor, I'd just like to point out before the hearing concludes is that there was an ex parte application for an order to show cause that was filed, along with the reply, and then also I wanted to address the issue because I have no access to this case.
I have seen that and I checked with the court. That's a Tyler issue. I'm sorry, I don't know why. Have you called Tyler Technologies?
I have, and as far as dates for orders and I'm at a complete loss. It's like I'm working in the dark.
But did you call Tyler Technologies?
Yes, we
And
did, and your court was looking into it, but
Okay.
it's difficult to do my job when I don't.
I understand, but notwithstanding the dates and all that, your client's affidavit was not, it didn't state the harm, even though it's common sense. It didn't state the amount of information I need, notwithstanding the pages being missing. That wasn't the only reason. Additionally, your order to show cause was submitted just recently from what I saw. So we're gonna move past that, but I am enforcing it. I got your order to show cause on February 2nd. Mr. Farran, do you have any questions about what your client is required to do between now and the child flying to Texas?
I do not, Your Honor. I'm just simply for the record, I understand that the attorney's going to be involved. I'm here all day, Judge. I'm not going anywhere. I wouldn't do that to the child or the parties. But I also ask just for clarity of the record as well, the itinerary directly to this, right? So that it goes straight to her as well as to us.
Okay, but your client is not allowed to respond directly to him if she has a problem with the flight.
We're not changing the flight, Judge. It should go to her.
Mr. Farran, from old times, I feel like I need to say that. If she is going to respond to him, it is not, do not put the child on the flight. I don't agree, whatever, okay? I feel like I just need to go above and beyond here on clarity.
So I will relay that, and she's here with me, and I'll relay it after we hop off this hearing. And just one more thing for record, for the record, since probably this will all get transferred. I've talked to Ms. I'm going to ask her to procure all the counseling records that she has, so we can provide them to the court, hopefully by the next hearing, just so Your Honor can see that she has done the counseling.
All right, so I will see you on February 12th at 11. And I hope I don't have to hear that the child, for some reason, did not get on that flight, because I would be very disappointed once again. Thank you very much for your time.
And Your Honor, I'm sorry, Your Honor, just to clarify, there's a distinction between counseling and an evaluation. She was to obtain an evaluation.
I agree.
And she never did.
I agree. All the other issues that remain I'm going to handle on the 12th. Right now, I just need that child back.
Sounds good, Judge.
Thank you.